Slip and fall injuries cover slip and fall, trip and fall. It can be water on the floor, a soft drink that's been spilled at a restaurant, or it can be a curb or a crack in the sidewalk. The law in Kentucky used to be very difficult for the plaintiff, that would be you, the injured person, to make a recovery, because the law said if it's open and obvious, that doesn't mean you saw it. That means somebody else might have seen it. If it was open and obvious, then you couldn't make a recovery. In 2010, that changed, but it was just one case. It was very narrow circumstances. And so we've sort of been waiting to see what the Kentucky Supreme Court would do with that. Well, in November, the Kentucky Supreme Court decided several slip and fall cases all on the same day, and it's clear now that in Kentucky, even if the condition was open and obvious and you saw it or should have seen it, if the property owner should have foreseen that you might trip over this or you might be injured by it, then the property owner still had the obligation to do something about it. A good situation would be if you have someone going into an emergency room who trips over a curb. That, in fact, was the case in 2010 that made the big change in the law. And the court said people who are going into an emergency room are distracted. By the same token, people going into a funeral home are elderly, bereaved, taking care of someone who's disabled. They're not looking at the curb or the step, and it needs to be well marked. And if it's a catchy problem, uneven sidewalk, poorly worn step, it needs to be repaired. If you've been injured in a slip and fall, one of the first things you need to do is contact an attorney who is experienced in slip and fall injury.